This conference will now be recorded.
So today's webinar topic is called 5 Misconceptions About Wills and Probate, the Myths versus the Facts. And I thought this was a great timely topic because it's something that questions are always coming up. And what better way to separate the myths from the facts than to talk about real life events? So over the years, I have coined a phrase that I hope all of you will kind of chuckle about and find some humor in. And I call it the myths, rumors, and my brother-in-law said. So have any of you ever said or heard someone say, I want a simple will. How much does it cost? So the first thing I want to explain is there really is no such thing as a simple will. A simple will makes a lot of wrong presumptions that somebody has a very simple situation and it doesn't take any thought process. And that's just not true. That's not the reality. We have to look at each person's dynamics, their marital status, what's happening in their family. Are they sick? Is a spouse or a beneficiary sick, or do they have a disability that we need to know about? All those questions, which should occur in a conversation with the client, leads us to determine how to write a will. So we can't tell somebody over the phone how much is it going to cost when we don't know them yet. It's almost like trying to call a doctor's office and say, well, I have this pain in my right side of my abdomen. Can you diagnose me? So we want to make sure that people get the right counseling and the right analysis. Now, how about this phrase? Have you ever heard somebody say, oh, it's not that hard to do. I can do it myself. I'll just download a form from LegalZoom. Well, I hear this quite frequently, enough that I could probably take my staff to lunch every week for every time we've heard this on the telephone. So I want to stop and talk about this for a minute because I am getting a lot of calls from people that think they should just go on the internet, download, for example, a durable power of attorney document or a last will and testament document, and that's going to be sufficient. It really is not. It's built with problems. So, for example, here in Florida, we had a major change in our durable power of attorney law in October of 2011 that now requires us, when we write this kind of document, to explain to the client that there are certain types of financial decision-making authority that not just have to be spelled out, but they have to either put their initials or their signature next to those paragraphs to indicate, are they giving permission to do that kind of action, or are they withholding permission? So most likely, whether it's LegalZoom or any other site on the internet, it's not going to be able to give that kind of information or that advice because there's just simply no conversation taking place. It's the same way as if somebody were able to walk into an Office Depot store. They're not going to be able to have a conversation with the person who works at the stationery store because they're not trained in the law. They can't answer questions. And unfortunately, if people do this, they download forms from the internet. Most times they don't cover what they need them to do, or we see they're not properly signed. So a document that doesn't have the necessary signatures or the necessary notarization is going to actually be an invalid legal document. So we don't want to create problems from the beginning. We want to do it correctly at first, so we don't later either lose the opportunity to fix it or we might not have an opportunity at all to fix it if either somebody later becomes incapacitated and they no longer are mentally competent, or the worst case scenario would be that somebody created their own last will and testament and then passed away, and now we certainly cannot correct that document. How many of you have heard this phrase? My neighbor told me what her lawyer told her to do, so I'm just going to do the same thing. Now, I hear this a lot when it comes to people being concerned about how they're going to pay for their future long-term care needs if they get sick. I hear it a lot when people say, I'm just going to sign a quitclaim deed and add my adult child's name onto the deed. Again, this is filled with problems. You have to realize that each person's situation is very different than their neighbor or the person that they play tennis with or play bridge with. It's not like everybody fits into the same size t-shirt or everybody likes the same flavor ice cream. So the point I'm making is that an estate plan needs to be tailored to the needs of the individual. What's right for your neighbor may not necessarily be right for you. How about this phrase? Have you heard somebody say, I don't want the government to take what I worked hard to save all my life? There's a lot of assumptions built into this sentence. Some people are afraid that when they die, their family won't get anything, that the state will. Or some people think that while they're alive, if they get sick, they're going to lose all their assets to the state where they live. The important thing to understand about these statements is they're made without proper information, without proper legal guidance. So it's very important, in order to look past the myths, the rumors, and my brother-in-law said, to get proper legal advice so that the documents that are created are legally enforceable and fulfill the needs and the goals of the client. How about this one? I only want a deed to avoid probate. That's all I need. Everything else is taken care of. Everything else is simple. This is also a very common misunderstanding. So let's talk about this for a minute. There are many different ways that a deed can be written. In addition, there's many different kinds of deeds. So the reason there are different kinds of deeds is deeds will give some guarantees or warranties when they're written a certain way, and other deeds have absolutely no warranties given. A quitclaim deed is probably the legal phrase you hear the most. And a quitclaim deed provides no guarantees, no warranties that the title, the ownership to the real estate is good. But people think this is something that can be done quickly, easily, and is very inexpensive. So they don't necessarily explore what are the other options and which option is best for me. Well, we want to be very careful about adding somebody's name onto a deed who is not a spouse, whether it be a significant other, a life partner, a boyfriend, a girlfriend, because how we add that name can have a consequence that we don't understand. So for example, if we add somebody on as a joint owner, but they don't live there, it's not their homestead, there could be a problem if that person has any financial difficulties, if they have judgments entered against them, if they go through a divorce proceeding, if they go through a bankruptcy. So we might want to explore other ways to put them on the deed, but not make them a joint owner where you can be subject to their financial mishaps. So again, it's really important that consumers get counseling, get the right advice, so their goals can be met. So after looking at all these phrases, you want to start to think about what are these phrases actually meaning? What are the goals by not consulting with an attorney? So when I hear somebody say, well, I want to save money, what they're really saying is it doesn't matter to them if there are problems later on that their beneficiaries have to deal with, and they're really not understanding that later on they could end up paying more money to try to fix the problem. So we want to do things right from the very beginning. When we hear people say, I want to save estate taxes when I die, if it's not written correctly in the documents now while they're alive, what they're really saying is, it's okay for my estate to pay the Internal Revenue Service as much tax as possible. But in reality, that's not what people want. They want more of it going to their beneficiaries. So the proper tax planning and proper tax language needs to be put in the document, whether it's a will or a revocable trust, when it's first written. You know, more and more, especially since the pandemic of the coronavirus started, you know, we hear people worrying. They have a spouse who's ill. They want to make sure that spouse is taken care of, but they don't understand, and so they don't realize that if things are not written or structured correctly, the consequence is going to be that if that spouse who's ill actually survives them and comes into the assets, they could become disqualified to receive government benefits that they need to help pay for their long-term care costs. And I'm sure you've all heard this one, I want to avoid probate, because that's one of the main topics we're all here to talk about today. But what it really means is people don't understand how the ownership, what we call titling of an asset, or the beneficiary designation, affects their ultimate decisions. So let me give you an example. Let's say that your name is on a bank account or is on some form of an investment account, and you have 4 children, but you only add one of your children's name on the account as a joint owner. Now you have a last will and testament, and in your will, it clearly shows that your intention is to treat your 4 children equally. Each one is going to inherit an equal portion. But we have a problem here, and most people don't realize it. There's an inconsistency between what the last will and testament says and what the outcome is going to be as to the bank account that has only one child's name on it. So a will is only going to direct the outcome of assets that are in your individual name, meaning there's no joint owner and there's no beneficiary designated on the records for that account. So here the inconsistency is that the joint owner, who's the adult child, will automatically inherit that at your passing. That asset doesn't go through probate, which means the will does not control its disposition. Now, sometimes people do this because they're thinking, well, what if I get sick? I need to have somebody who's going to have immediate access, be able to pay my bills. And that's a very, very relevant and very important concern to have. But the proper way to do it is to have a well-written, durable power of attorney that gives legal permission to access the accounts, to be able to pay the bills without making that individual an owner of your accounts or your assets. So the assets remain protected from any personal financial events going on with your trusted fiduciary, and you still achieve the outcome that the will says, which is that you want that account to be equally divided among all 4 children. So it's very important that we look at the complete big picture We see what is it you want, or what does your will currently say, compared to how are the assets titled, and are there beneficiary designations that are different than what your will says. So when you listen to myths, rumors, or my brother-in-law said, here are the likely outcomes. Number one, you're likely to have a defective estate plan. Number two, you're going to have an outcome that is not what you had intended or desired. You might actually create a consequence that you never imagined and certainly never intended. And it will likely cost more money to either fix or resolve than you had ever intended. So now that we've talked about the importance of setting goals and being clear about what your intention is, let's talk about two very important terms, legal terms. The first one is probate. And very simply, probate means the process by which we transfer ownership of assets from somebody who has died to a beneficiary. Now, a more complete definition is that probate actually involves submitting the original last will and testament to the probate court in the county where the person lived prior to their passing. The judge reviews the will to make sure it was properly executed according to Florida law, and then the judge accepts it as a valid legal document and will sign an order accepting the will and appointing the individual you named in your will to be the personal representative. Now, I know many people who live in Florida are not originally from Florida, but are either from the Midwest or the Northeast. So in other areas of the country, there's a different legal term that is used for the personal representative, and that word is executor, to refer to a male, or executrix to refer to a female. All those terms mean the same thing. It is the person that is entrusted and appointed by the court to carry out the terms of your instructions in your will. Now we call, or we refer to the executor or the personal representative as a fiduciary. So a fiduciary is a person that's held to a high standard of care when they act on behalf of another person. So here in the context of a probate, the personal representative is held to a standard of care to marshal the assets, mean to identify what did this person own when they were alive, gather those assets together, place them in a financial institution, providing necessary FDIC protection. And so it might involve more than one financial institution. And we won't get into this in depth today, but the fiduciary needs to make a decision when it comes to appreciated assets like stocks, whether they should keep the stocks or whether they should liquidate them in order to prevent possible loss, which could mean less monies ultimately being distributed to the beneficiaries. So fiduciaries, whether they're a personal representative or somebody under a power of attorney, are held to a high standard of care. So when you're thinking about who you want to name as your personal representative, you want to think in terms of somebody that is mature, somebody that is fiscally responsible, and somebody that you've had a discussion with who's actually willing to take on this role when the time comes. I don't recommend that people necessarily base their decision on the eldest child, which happens to be a very common way of making this decision, but it doesn't always mean that the eldest child is the most responsible or fiscally sound or that they have the time based upon their other responsibilities, which might include family obligations and work obligations. So a little bit later in this webinar, we're going to talk about what are some other options if we did not name the eldest child or other children. So now we're going to get into some of the most common misconceptions that people have about wills and probate. So here's the first one. If you die without a last will and testament, the state will get everything. Do you think this is true or is it false? Well, the answer is that it is false. Now, every state in the country has a law. It's referred to as the law of intestacy, and it means that if a person did not make a last will and testament when they were alive, that would say who would inherit and who is going to be their fiduciary, then the state has a law that says who's going to inherit and in what proportion. The law of intestacy is basically based upon the theory of the next of kin, meaning those people that are in the bloodline of the decedent. So for example, here's where we have to know whether somebody is single versus married, for example. So if they're single, we would first have to look to see, do they have parents that are still alive? If no parents, do they have children? Do they have siblings? So we work through this process of determining who is going to inherit and in what proportion. Now, if somebody is married and they die without a will, it gets a little bit more complicated because there are two possible options depending on whether the surviving spouse is the parent of the surviving children or if they're not. So if it's a first marriage, meaning the surviving spouse is the parent of the children of the decedent, then essentially that surviving spouse would receive all assets. But when the surviving spouse is not the parent of the decedent's children, the distribution scheme is altered, where there's a certain proportion that goes to the surviving spouse, and the remaining portion is divided among the decedent's children. So what I'm hoping you start to realize as we talk through how wills and probate work is that you'll start to see all the advantages of making a last will and testament and doing it correctly so that your wishes are implemented and followed, and it creates far less family disharmony and potential chaos after you've passed away. Now, another issue that arises when somebody dies without having made a last will and testament has to do with, is anybody going to be disinherited? And the answer is no. Everybody who's in a category, so let's say the category is siblings, because there were no parents, there were no children, even if the decedent didn't like one of their three siblings, that sibling is going to be treated under the law equally to the other two. So the only way to disinherit is by making the last will and testament and specifically stating that that individual is being disinherited. Now, can somebody contest? Well, anybody can contest a last will and testament. Our foundation for our legal system in this country is that the courts are open and there is encouragement that people who have a valid basis and evidence to believe that a will might have been obtained through fraud or undue influence, that they should come forward and bring this to the attention of the court so that if it is true, the wrong can be righted. But there is no way to contest the law of intestacy. It is the law that applies when somebody dies. So here, the moral to this first common misconception is that a will should be tailored to the needs of the individual. There is no simple will. There is no form will. It needs to address all the different issues that arise having to do with marital status, children, relationships with potential beneficiaries, whether there's anybody that the person wants to disinherit or wants to perhaps treat somebody more favorably, either because of the relationship or maybe that person hasn't been as successful in their life, or perhaps there's a beneficiary who has a disability or an illness. So we have to make sure that their inheritance is properly protected, most likely by being written in a special needs trust, so that the inheritance does not cause that beneficiary to lose their government benefits, such as Medicaid, SSI, or food stamps. The second most common misconception is the phrase, probate is expensive. And I'm sure you've heard this phrase at least once, if not 10 times. Again, this phrase comes from the misunderstanding of not knowing that here in Florida we have several different types of probate, and they're each intended to help a different type of situation. So I'm going to explain each type of probate and give an example of how and when this would be appropriate and what to expect. So the first type of probate we have in Florida is called formal administration. And as you can tell from the word formal, it does mean that there are requirements that have to be met by the personal representative and their attorney to go from the opening of the estate to reach the end, which is the place where we would satisfy any claims of creditors, pay taxes, and make the final distribution to the beneficiaries. Now, because in formal administration there are more requirements that have to be met, it does take a little bit longer than the other two types of probate that we're going to talk about. On average, barring any unanticipated problems, a formal probate would generally take about 4.5 months. And that's assuming that we don't have anybody contesting the will, that we don't have problems with creditor claims where we might have to pursue a lawsuit. So the time frame is approximately 4.5 months, but when the personal representative is appointed, the order will actually allow the estate to stay open for 12 months. And if for some reason more than 12 months is needed, we can simply go back to the judge and ask for an extension. Now, formal administration is what we use if the assets of the decedent are greater than $75,000. So what are the assets we have to look at? They include real estate in Florida, all kinds of bank accounts, investment accounts, cars, boats, mobile homes. The key is anything that was in the name of the decedent that didn't have a joint owner and didn't designate a specific person or charity as a beneficiary is going to need to go through the probate process in order to be distributed to the people named as the beneficiaries under the last will and testament. So that's the key to keep in mind. No joint owner, no beneficiary designation. Now, Florida does have a law that establishes what is considered to be a rate of reasonable compensation for the attorney who represents the personal representative. There's a similar statute that also establishes what is considered to be a reasonable rate of compensation for the fiduciary. The schedule, as we refer to it, for the attorney compensation starts with a base of $3,000 when the value of the probate assets is $100,000 or less. From that base, the fee can be increased, and that is based upon a tier schedule of going to the first $1 million. It is calculated at 3%, going for the difference between 100,000 to 1 million. And then above 1 million, the additional level is calculated at 2.5%. Now, while that is considered to be presumptively reasonable, the statute also says that the personal representative, the beneficiaries, and the attorney can agree to a different type of compensation. So that's always an option. Now, the other thing to keep in mind when determining if your assets would be greater than $75,000 to necessitate a formal administration is the fact that under our law, we do not count the value of the Florida homestead. So we actually carve that value out and we look at all other assets. So if somebody owns non-homestead real estate, such as a rental, that would be included. The second type of probate in Florida is called a summary administration. And as the word summary indicates, it is a shortened version of probate. And we're allowed to use a summary administration process when the total assets of the decedent is less than $75,000. So $75,000 is our demarcation point. Again, just like in formal administration, we do not count the value of the Florida homestead. So let's do an example together. Let's say we have an estate of somebody who's passed, and they have a Florida homestead worth $200,000, and the only other asset that needs to be probated is a bank account where the value is $50,000. Well, we would subtract the $200,000, and that would leave us with the $50,000 bank account, which is well below the $75,000 threshold. So we can use the shortened form of probate called summary administration. Now, the summary administration will work in most cases. For example, we are not having the judge appoint a personal representative in a summary administration. So if, let's say, the decedent died in a car accident that was caused by somebody else, not the decedent, and the family goes to a trial attorney and is counseled about their rights as survivors, and they decide they want to file a lawsuit for wrongful death. Well, in that example, they cannot use the summary administration form of probate because there will not be a personal representative appointed. They would need to do a formal probate because in order to bring the wrongful death lawsuit, they need somebody who has legal permission to speak on behalf of the decedent, and that could only be given in a formal administration type of probate. So I hope that helps you see when we would want to use a formal administration and when we can use a summary administration. Now, Florida has a third type of probate, and we call this ancillary administration. And the word ancillary signifies that it's secondary to something else. So this is a form of probate we would use if somebody who died was not a Florida resident. They were a resident, let's say, of New York, but they happened to have an asset here. Maybe it was real estate. So their main probate is going to take place in New York, but the secondary or the ancillary probate is taking place in Florida. So we would use an ancillary form of probate, And it's a combination of what we go through in summary and what we go through in a formal administration process. But we do need to show that the other state has undertaken its probate. We may even need to provide our Florida court with a copy of the order from New York showing that the personal representative was appointed. So probate is not necessarily expensive. It is going to depend on what type of assets are involved. Just to rebrief, with the formal administration process, we have a law in Florida that establishes a presumptive rate of compensation. We do not have a similar statute like that for the summary or the ancillary. Many lawyers will provide those other services either based on their hourly rate or a flat fee if all information has been properly shared and disclosed, and so we can determine what needs to be done to complete the probate process. The third most common misconception that I see is the comment that probate takes years to complete. And so this phrase then gets transformed into people saying, oh my gosh, I don't want things to go through probate. It'll take years or it'll take forever for my beneficiaries to get the assets. It's not what I want. So again, this is a myth, but we have to look at how did this myth come to be? What's behind it? So for those of you who may not recognize the beautiful woman in the photograph, that is Jacqueline Onassis, the wife of our late President Kennedy. And the reason I chose to use Jacqueline Onassis as the example is because to understand this myth, you first have to understand the difference between a taxable estate versus a non-taxable estate. So in our country, we have tax laws that apply when a person dies, and it determines whether there is a tax to be paid to the Internal Revenue Service based upon the value of the decedent's assets. So this law has changed quite consistently every few years. Usually it seems to change when we have a new president in office who proposes to Congress that the taxable exempt amount be increased. For this current calendar year, the amount that an individual can pass on in assets without incurring an estate tax is approximately $11.58 million. So if somebody has greater than that amount of assets, they have what we call a taxable estate. Whereas somebody who has less than that amount, the exemption covers everything. There's no tax to be paid by their estate. They have what we call a non-taxable estate. Now here's where the history of Jacqueline Onassis comes in. After President Kennedy died, Jacqueline Onassis became involved with a very wealthy gentleman, and she inherited assets from him. At her passing, it was determined that she had a taxable estate. So that meant not only did a final income tax return need to be filed for the last year she was alive, but another kind of tax return had to be prepared by an accountant, which is called a federal estate tax return. Now, it can take some time to prepare this kind of return, although it must be filed within 9 months of date of death. And then IRS is given a very long period of time to take to review and, if necessary, to even audit the return. And that's really why we see situations like with Jacqueline Onassis, where it did take several years for her probate process to be complete. It wasn't because the court held things up. It wasn't because her personal representative didn't do what they were supposed to. And it certainly didn't mean there were any issues with the beneficiaries cooperating. But what it meant was that the judge would not allow the final assets to be distributed and the case closed until the judge was assured that any tax that was due to the federal government had been paid. And the way that the court knows this was done is IRS, once it has received the money for the tax due, they will issue a document called a closing letter, which acknowledges that the federal government was paid. We then take that letter and we file it with the probate court. And when that is done, the judge knows that the probate process can proceed and the judge can allow the personal representative to distribute the assets and close the estate. So when you hear the phrase probate takes years to complete, I want you now to picture in your mind somebody very wealthy like Jacqueline Onassis who has a taxable estate, and that's the reason why the probate can take longer. But as you heard me say earlier, most formal administrations are completed within 4 to 4.5 months, absent a situation where maybe there's a lawsuit, a personal injury matter that could take longer to resolve. The summary administration form of probate is usually done once we file all the papers. Within 2 weeks, we can get the signed court orders and be able to deliver the orders to the client who can then claim the assets. And similarly, with an ancillary probate, that's done within a very short time frame as well. The fourth most common misconception about wills and probate that I hear is when a client says, I should pick my eldest child to be the personal representative of my will and to be the successor trustee of my trust. Now, for some families, this can be a good idea, but not for all. So here's what I want you to think about. There are certain things that have intrinsic value. They mean more than the actual value of the asset, whatever that asset may be. And to me, one of the most important intrinsic values is maintaining family harmony. Unfortunately, family harmony can be disturbed if we appoint one child when we have multiple children, and the other children start to feel that their sibling is not sharing all the information with them. Maybe they're not keeping them informed, or that they're possibly intentionally withholding information. That starts to unfortunately create these undercurrents within the family that can many times lead to families being broken apart by the time the estate is distributed and closed. If there was sibling rivalry before the individual died, it's probably also not a good idea to name a child as personal representative or as successor trustee, simply because that undercurrent of all those years of sibling rivalry are just going to be more pronounced now that the parent has passed. So there are many benefits to naming a disinterested fiduciary. A disinterested fiduciary would be somebody that's not a beneficiary. They have nothing to gain by serving in this role, but everything to gain for the family and for the intended beneficiaries, because it will help to maintain the family harmony. That person will more likely be viewed as being open, being transparent, keeping everybody informed because they have no personal stake, no reason not to. And it should hopefully keep things at bay with any sibling rivalry that existed before the passing of the decedent. So keep in mind, you have the option of naming perhaps a trusted friend, or if your wealth level is of a certain level, You probably also want to explore working with a corporate fiduciary. This could mean a financial institution. It could mean a trust company to serve as successor trustee. And some of the advantages of working with a corporate fiduciary is that they've gone through training. They've gone through ongoing educational classes each year that is required in their profession to understand the nuances of properly investing the assets, protecting the assets. If a beneficiary cannot be located, they will go through the proper channels to find that individual. And so there are a lot of benefits. They may have a real estate department. So when there's real estate in a probate or in a trust, they have to make sure that the property is secured, that it does not deteriorate or decline in value. And of course, depending on the instructions in the will or the trust, it'll either be distributed to the beneficiaries or there may be a direction to sell it and then distribute the proceeds. So a corporate fiduciary will have all the experience that ordinarily most people don't have, and they'll be able to fulfill the role of fiduciary and fulfill their duties in a timely manner. So I hope all of you are laughing as you see slide number 5. The fifth most common misconception is people still say today, I can disinherit my spouse and leave everything to fill in the blank. My boyfriend, my mistress, my lover. Well, believe it or not, it doesn't work that way in Florida. So Florida has always had a law to protect the surviving spouse, and it's called the elective share law. Now I'm going to talk to you about what the law used to be, why it changed, and what it is now. So originally, Florida's elective share law said that if a decedent attempted to disinherit their spouse, meaning to leave them nothing, that would not be the outcome. The law would essentially rewrite the will to protect that surviving spouse and to give them 30% of the value of the assets going through the probate process. Sounds good, doesn't it? Well, a lot of us thought it sounded like a good plan until about 15 years ago. There was a real life situation where a married couple went to an estate planning lawyer, met with the lawyer together, talked about writing an estate plan. The lawyer wrote a will for the husband as well as for the wife. The documents were signed. And several months later, the husband called up the attorney's office and said, I'd like to come see you alone to talk about my will. The husband went in to speak with the attorney and admitted that he was in a relationship outside the marriage and he did not want to leave anything to his spouse. So the attorney counseled the husband that the way that could be accomplished was for the attorney to write a legal document called a revocable trust, to have the client transfer ownership of assets in his name into his trust. And the reason the lawyer told him that was the best planning option was because back then, the elective share law that protected the surviving spouse could only go after probate assets. It could not go after an asset that didn't go through the court process. So the husband had the attorney write the trust agreement. He followed the attorney's instructions and moved the assets out of his name into his trust. And lo and behold, as you can imagine, he passes away first. The wife goes to probate the will, and she learns that there are no assets to go through probate. And she's, as you can imagine, she's just horrified. She is stricken with grief, and now she finds out that he has basically made her a pauper. And it was this specific South Florida case that led sections of the bar to propose to the Florida legislature that the elective share law be amended to be able to reach non-probate assets, including assets owned by a revocable trust, assets that pass outside of probate, such as life insurance proceeds or proceeds from an annuity, which is a type of insurance product. So now, under current law, the surviving spouse has protection of the 30% elective share as to probate and non-probate assets. So if when the 30% calculation is done, there are not enough probate assets to satisfy the 30%, that's when the personal representative can reach the non-probate assets in order to satisfy the elective share for the surviving spouse. Now, if somebody does want to disinherit their spouse, then they really need to consult with a family law attorney. The two exceptions to the elective share law in Florida are to either enter into a prenuptial agreement with your fiance before getting married, where each person is represented by an attorney. Each person is making full and fair disclosure of their assets and income in writing to the other, and they are counseled as to what legal rights they could be giving up. The other option, if a prenuptial agreement is not signed before the marriage, is to have a postnuptial agreement, meaning it's done after the marriage ceremony is performed. So those are the only exceptions to the Florida elective share law. And thank goodness we've done that in order to protect our surviving spouses. Now, most people have the tendency to think that making a will, doing estate planning, is something you only do when you reach a certain age, when you're older. Sometimes people come up with the magic age of 60 or 65. But as you can see here, we have two photos. One is of Anna Nicole Smith. The other is of the late Prince, who died 3 years ago. And the reason I am using them as our examples is that the estate plan, and sometimes you hear me refer to an incapacity plan, which are legal documents allowing somebody you trust to make your medical and financial decisions if all of a sudden you're incapacitated. It's important for everybody at every age, as soon as they become legal, meaning age 18. So there's no magic age we reach that we should start to think about this. Now, with Anna Nicole Smith, the thing that she didn't plan for was she had a young adult son who overdosed, but she also had a fairly newborn baby by the time she died. And she did not provide for naming a guardian for that child. And fortunately or unfortunately, it had to go through the court process down in Miami-Dade County to determine who should be the guardian of that child. So every adult should have a legal plan. My second recommendation today is don't make mistakes that can be avoided and should be avoided. And the perfect example of this lesson is Prince. Here you have a man who was extremely successful in his career, multimillionaire, and even with all of that, he did not take the time to go and get proper legal counseling. He actually died without having a will, without having a trust. His estate is unfortunately still going on in the court system. Now, the judge has decided that his estate should be probated according to the law of intestacy that we talked about at the beginning of today's webinar, and it's being distributed among approximately 6 of his siblings. But in the meantime, there are so many complications that are being dealt with by the attorneys and the court that could have been avoided and should have been avoided, that the estate is taking a very long time, and it is running up legal fees. So please take the time to do this. I know we're all dealing with these additional challenges posed by the coronavirus, but if you haven't done your plan, start to think about it now. Make a list of what's important to you. Write down what your goals are. Attorneys are doing consults through video right now as we're all trying to stay healthy. And there are ways to have your documents signed even during quarantine. So while human nature tends to put off tomorrow what we can do today, my advice is be proactive and make your decisions after you've been informed rather than making your decisions out of fear, out of myths, or out of rumors that you've heard. So when you're looking for an attorney, whether you come to me or another board certified elder law attorney, you want to look for somebody who certainly has the experience, but somebody who's going to take their time, listen to you, what's important to you, and not rush you through the process. You want to work with somebody who is going to get to know you, your family dynamics, your goals, your concerns, and be able to identify potential problems and what the options are to fix those potential problems. You want to work with somebody who does this every day in their practice, not somebody who's just going to dabble, and somebody who's continuing to become knowledgeable, to become educated every year so they can share that knowledge with you. And last but not least, you want somebody who's going to walk you through the importance of having a legal plan that works both while you're alive, that's the incapacity part of the plan, as well as working after you've passed. That's the will or the trust part of the plan. So now if anybody would like to ask questions, please feel free to unmute yourself, or you're welcome to write a question in the chat box. So I see we do have one question in the chat box, and the question is, can you select two people to be the executor, or what in Florida we call the personal representative? The answer is yes. You can name multiple people. What is important for you to think about when making that decision is, can the two people you're about to name work well together? And only you can answer that question. The other thing I would probably advise is not to go beyond two people. So if you have several siblings or several children, I wouldn't encourage you to name 3 or 4 people to work together. That is probably going to make it more difficult and less efficient. So feel free to ask questions. I'm hoping that today's topic has sparked some questions, some concerns. Okay, well, I'm surprised that we don't have any questions. I would like to invite all of you to join me next Wednesday. I know normally we hold these webinars every Friday, but next Friday is July 3rd and many businesses will be closed. So just for next week, we're moving our weekly webinar to Wednesday. The same time is 12:30. And we're going to have a conversation about navigating through different legal issues that have arisen because of COVID-19. And we are going to have at least half the time dedicated just to sharing information and taking questions from those who are attending. Please go to the firm's website to register for that, as well as future webinars. The calendar on the website will tell you all the webinars that I am hosting at least through the end of July going into August. And I wish everybody a great afternoon. Please stay healthy, stay safe. I do see another question in the chat box. The question is, how do you legally remove a deceased beneficiary from your will? Oh, wow, this is a really great question. So it will depend on how the language was written as to that individual. For example, if the language says, I leave 10% to John Smith, period, the potential outcome could be that we then have to go through an interpretation process to see if the other living beneficiaries inherit. It would be much better if the will is written, I leave 10% to John Smith, provided he survives me by 30 days, and if he doesn't, then this would be the outcome. So the answer to the question is it's going to depend on how that paragraph in the will is currently written. If the paragraph provides for an alternative outcome because John Smith has already predeceased you, then there would not need to be a revision to the will. But if it doesn't contain that language, then we may need to prepare what's called a codicil. So a codicil is a legal document that, rather than changing everything in a will, only changes one or two sections. So it actually works with the will. We keep the will and we keep the codicil. So I hope that answers your question. I see another question was just typed in the chat box. It says, if you do have 1 out of 4 children added to your deed and the property passes to that child automatically, and that child does want to follow the decedent's wishes and distribute the property to the other siblings, will the distributing child have tax liabilities? Wow, another great question. So I wouldn't word it as tax liabilities, but there will be tax impact because only that child was the recipient. And so then the child becomes the new owner, and now they're actually gifting. So gifting is a different legal impact than inheriting. So I'm so glad that you asked this question. And again, it shows us that these conversations need to take place in order to determine the best way to plan each person's estate and what the concerns are and how to best address those concerns. So thank you for sharing that really great question. So thank you everybody for joining me. I look forward to you joining me, if not next week, down the road. Stay safe, stay healthy, and have a great weekend.